Well, welcome everybody to the Step 2 program annual client meeting. This is the web version, which we've done because I had to reschedule the June 10th meeting, and for that I apologize. We had to send it over to the 17th, and some people couldn't make the 17th, so we've done this web meeting for them. So I just want to welcome you all. Since we've already muted everybody's phone, I'm going to pass by this. And if you're watching this on the recording, of course, you don't need to be concerned about that. So here's our agenda today. We're going to talk a little bit about the state of the firm, and then I'm going to talk about the Step 2 program and do a little bit review of some of the concepts that are involved. Then we're going to talk about succession planning, particularly for the firm, and then we're going to have a legal update, and then we'll have some questions and feedback. So, state of the firm. First, I want to just go over the service team. We have me, of course, and Alicia. We have our client advisory board, and for those planning partners that work with you and with us, they're part of our service team as well. I want to go over our services a little bit. Of course, we do estate planning, plan maintenance, estate settlement, and probate, and of course, we do trust advisory services. Now, one of the services that we have not emphasized until recently is called the special delivery system. And this is designed for people as they get older who are unable to make our meetings. What we do is we get together with them and their family and figure out the best way for them to get the updates, to update their assets and everything. For some of them, we'll do individual meetings by web, or they'll attend by web. And various different systems and practices can be adopted for each individual. And in particular, because we have the Trust Protector services, if an individual becomes disabled and they're no longer able to update their trust, their trustees can hire us to update their trust for all the boilerplate, and we can do that every year, every other year when it's time to update that particular trust. So that's the special delivery system. Another service that we haven't particularly emphasized as of late is the administrative support team program. And if you remember, we talked this last year about the what we call sometimes the Wisdom W. The administrative support team program takes place over here in the two emphasized boxes: the settlement security system and the administrative support team program. The administrative support team program takes place once the settlement security, once we settle your trust, gone through the administrative trust, and at that point the successor trusts are started, and in many cases we have individual trustees who really, it's not their day job to be a trustee of a trust, so they need some help and advice. So what we do is we establish a trust administration policy with them, which would include investment policy, distribution policy, tax policy, who's going to do the income tax returns for the trust and all of that. And then that gets reviewed every couple of years, 2 or 3 years for that trust. And if that's starting to sound like an estate plan for a trust, that's exactly what it is. And so the trust can join the Step 2 program as well, so that the trustees and the beneficiaries of the trust can get the benefit of the program as well. So that's the administrative support team's system. We have our administrative policy advisory services, and then of course when they're in the program we have wealth reception trust advisory services. In other words, we provide assistance to the beneficiaries for them to understand how they can plan with their beneficial interest in the trust, and to make it clear what influence they can have over the trust and what their relationship to the trust is. And then of course again we have Trust Protector updating services, because the trustees of the long-term trusts can appoint us as a trust protector, and we can continue to update the boilerplate as we do every other year for all of our existing clients. And if you think about it, we started doing this kind of planning in 1996, so that's 20 years, but if someone becomes a beneficiary of a long-term trust at age, let's say 45, their life expectancy could be 30 to 40 years, and so their trust is going to be going along a lot longer than we've actually been doing this kind of planning, so it's important for them to get updates as well. So, and then of course we have business transition planning services, not just for us, but for other people. I've developed a concept called the Business Owner's Blueprint. I'm not going to go into it in any detail here, but it's a way of helping business owners essentially plan for their business and what they want to have happen in their business going forward, in particular to transition either to sell it or to transition to the next generation if it's a family business. Okay, so I'm not going to talk too much about the program fees today. There will be more about that a little bit later in this program, but we have in prior years talked about the program fees, and what we keep getting as feedback is, Frank, you have to decide what the program fee should be, and then we'll decide whether we're going to afford to pay it. So that seems to be the way it's going, and of course we had to increase the fees this year for a bunch of reasons, including increased costs. So we'll be continuing that way. We'll try to keep the program fees down. So I want to go into a bit of a step 2 program review, and what this review comes from is a workshop that's been developed by the National Network of Estate Planning Attorneys as an introduction to the way we do planning, and it's called The Truth About Estate Planning. I'm going to only give you a small portion of it. It's actually a 2 to 3 hour workshop on the ins and outs of planning the way we do it, the maintenance program and everything. But I wanted to go over the beginning of it and some of the concepts so that I can make some particular points with regard to our program this year. So the truth about estate planning is, of course, that most estate plans don't work. They just don't work. So what do we mean by that? What we mean is that the most plans, that people do on a transactional basis don't actually meet their expectations. And to understand what that means, we've developed the snapshot test. And what that means is if you've died, for example, and you're up in the clouds looking down, which of course is the best option, the best alternative, you're looking down, and if everybody's running around doing the things that you expected them to do and not doing the things that you expected them not to do, then that's a plan that worked. Doesn't matter whether it's a trust-based plan, a probate plan. If everything is going the way you expected it to go, and people are doing what you expected them to do, then that's a plan that worked. Anything else is unacceptable. And for people to be able to get that picture, many people have a picture of what they expect to have happen, and when they come to do planning with us, we help them kind of sharpen that picture. And one of the ways that we help them sharpen that picture is through the definition of estate planning, which you are all very familiar with. I want to control my property while I'm alive and well. I want to plan for me and my loved ones if I become disabled, and then give what I have to whom I want, when I want, the way that I want, all while assuring my wisdom is transferred along with the rest of my wealth. So that's kind of the target that people use in beginning to understand the various different issues that they should consider when they're doing their planning. So what I want to do is I want to go over the 4 keys to an effective estate plan. And this is one of the most important parts of the overall presentation. And there are 4 keys, of course. Personalized counseling, proper asset ownership, a formal review process, and a controlled transfer process. So what do we mean? You all know what we mean by personalized counseling. You've all been through it. But most people don't really understand the importance of it. And fundamentally, the importance of personalized counseling is that most people need to be taught about various different options of things that they can do. If you don't know what the options are, you're not going to use them in your plan. So for example, we often use the school bus story, which you're all familiar with. Well, that teaches some options about how to help people transfer their wealth and prevent their wealth from being taken by the creditors of their beneficiaries. So, you know, if there's a lot of different personalized counseling issues that people are completely unaware of and that become somewhat surprised about when they hear our stories, and that's how we use our stories, is to help people understand what the options are. And again, if you don't know what your options are, you're not going to use them in your plan, and you may not be able to do all the things that you would normally really want to do. So personalized counseling is a really important key to having an effective plan. Then, of course, we have proper asset ownership. Oh, and let me just back up a little bit on personalized counseling. So, you know, 10 years ago, I started doing counseling in the network method, for example, 20 years ago. But let's say 10 years ago, I did a plan for someone. I did all the bells and whistles, all the things that I'd learned. We'd go to Collegia 2 times every year, and all the network members teach each other various different things that they've learned or developed. And then we come back and we use them for planning with our clients. And so 10 years I used all the bells and whistles that I'd learned so far with the network for a client. And then, of course, the client is coming in this year. And in the interim, we've had, in those 10 years, we've actually had 20 collegia with all the teaching that's involved between the network members as attorneys. And we've learned a lot of new stuff. And so we're going to give our clients our best personalized counseling this year based on what we've learned. So which plan would you rather have? The one that was done 10 years ago or the one that we're doing this year? So that's personalized counseling. It's important to know that it needs to be updated. We'll get into that in a couple of minutes. So, and then of course there's proper asset ownership. So let's say that I've done a plan for my wife and I. We have a revocable living trust plan. I've established in the plan a family trust and a marital trust. And I have put in provisions about my cottage in New Hampshire and various different things that I want to have happen. And then my lovely wife Carol and I have all of our assets titled jointly. Well, what happens then when I die is that all the assets go to Carol and my trust gets completely bypassed. So it's important to make sure that the titling of the assets and the beneficiary designations of IRAs and insurance are all properly lined up with the instructions that we're leaving behind in our plan. So proper asset ownership is really an important key, and that's what we often refer to as funding, and that's why we update the funding every year to make sure that everybody has proper asset ownership as part of their plan. And of course, there's a formal review process, and I've just talked a little bit about what happens if I did a plan 10 years ago and then I do one now, and the difference in the counseling and the various different types of things that are options in those plans. So it's important to make sure that we have a review process. Now, typically and traditionally, lawyers tell clients when they've done their plans, it's been very nice to know you, here's your documents. I look forward to seeing you in 3 years when you come back. I'll send you a reminder. And of course, the reminder comes out in 3 to 5 years, and the client puts it on the banister and says, well, the attorney must need to pay their mortgage. And so they decide not to proceed with that, or they just don't do it. They've got other things to do. So 3 years goes by, 4 years goes by, 5 years goes by, and if you think about what's happened in the last 5 years of your life, you may realize that there's a bunch of things that need to change, or a bunch of changes that have occurred in your life, both financially and personally, that will really affect the kinds of things that you want to, decisions you want to make in configuring or deciding what your plan says, what your instructions say. So having a formal review process for your plan is an important, very important key. So Now, controlling the transfer process is also important. And what has to happen is the people that you're leaving behind, what you're doing, what most of our clients are doing, is they're doing their planning so that things go smoothly for the people that they leave behind. And what they want to do is they want to have a controlled transfer process so that all of that goes smoothly. So how does that happen if people who are involved in the plan and the people that are appointed to carry out your instructions, like your trustees and your executor or whoever it might be, don't really know what to do, how to do it, or how to pay for it? Well, what happens then is that they call up the attorney and they come in and they sit down, and that's when their education process starts. And so, if they don't know what to do and they don't know how to do it, how would they know whether the fee that's being quoted is a reasonable fee? They just have no leverage at all. But of course, in our process, what we're trying to do is fully disclose the fee. We're trying to have all of our clients and helpers well educated so they do know what to do and how to do it. And of course, they will also know how to pay for it. So those are the really important keys to an effective estate plan: personalized counseling, proper asset ownership, formal review process, and controlled transfers. So that is why we recommend the three-step strategy. Developing your plan with counseling-oriented planning partners. Commit yourself and your family to a formal continuing maintenance and education program. And securing appropriate assistance for you and your family to transfer your wisdom along with the rest of your wealth. That is the three-step strategy. And so the Step 2 program is the second in those 3 steps, and that is to commit yourself and your family to a formal and continuous maintenance and education, with the emphasis on the word commit. And again, here's that protocol that we sometimes refer to as the Wisdom W, and the emphasize that the dark blue boxes in the middle there are really what's considered the Step 2 program. So there's the financial integration of your assets with your plan and the instructions that you've done, which we sometimes refer to as funding. The continuous commitment compact, which is your agreement with us that everyone is signed about how the Step 2 program is supposed to go and what we're offering in terms of estate settlement. And then finally, of course, the Heritage Design Learning Solution, those 4 nuts and bolts classes that we give every year, along with other things that we do as well. So that's the Step 2 program. That's the middle part of the Wisdom W that is our overall protocol. So in order to effectuate proper asset ownership and a formal review process, that's what the Step 2 program is really all about. So the Step 2 program, and we haven't emphasized this in the past, but it's really a group program. We meet in groups, we have webinars in groups, we have our document updates in groups, and there's a very good reason for that. So first of all, it's designed to make things go smoothly and inexpensively for your loved ones. It's designed to provide the updating and education as well inexpensively. It's also designed to prepare your assets efficiently and inexpensively so that they can be transferred. And it's designed to minimize the overall cost of your estate plan. So those are the fundamental purposes of it being a group program, because if we do it individually, it becomes a lot more expensive. Some of you may remember that years ago we used to have individual meetings with our clients, and after a while it just became way too much to do. If you think about it, when you have 20 or 30 or even 100 clients, then you're doing a couple of update meetings every week. So that can be very difficult. So it's a group program so that everyone can take advantage of the system. Okay, so for those of you who are just joining, please be sure to mute your phones or your microphones so that we don't have feedback as we go along. Well, there will be a point points in this presentation where we're going to have questions and answers. So that's the time when we can unmute things so people can break in. So as part of the Step 2 program, we have the annual funding updating process. So I want to go over that, which we've just concluded. So in January, we have our registration. Everybody gets a bill in December, and in January, that's the time when people send back their registrations for the program. Then in February, we send out our welcome letters, and the welcome letter includes the year's calendar. In that calendar are the dates for the annual client meetings, for the client update program in the fall, and it also has in it the deadlines for various different things that are supposed to happen during the year. And then in March and April, that's when the client's job is to update their funding. So in your Blue Book, which you get at the end of your initial planning process, there is an asset review report, and we give that to you every year when you come to the annual client meeting. It's in your Blue Book. So in March and April of the following year, you go into your Blue Book, and you will find in the updating, under the updating tab, also referred to as keeping current, you'll find your asset review report and some instructions. So take the asset review report out of the Blue Book and then prepare your asset review report itself. Now, that is a key aspect of this. We send the asset review report because, and I'll talk about this in a minute, we have very specific reasons why we need to have you fill the report out the way it is, not send it back in other ways, or not just send it back with a note that says nothing's changed, because obviously things have changed, including the values on your assets. So send us your asset review report with and if you have new assets, we need to have new account statements so that we can confirm that the accounts are actually titled the way that they're supposed to be titled, consistent with your instructions and your original funding instructions. Also send out a supporting document in by the deadline, and that deadline again is in the annual calendar. This year it was April 22nd, I believe. It's really important for us to make sure that all of your assets are titled the way they're supposed to be. So what happens then is when those reports come in, Alicia reviews the asset review report, and if she finds that there's information that she needs or that's not particularly clear, she will call you up in most cases or email you asking for additional information. And then Alicia updates each asset in your data file. Now, think about this. Each of our clients has their own data file. And in that data file is all of the instructions about how the documents are to be generated, and all the instructions about the funding, has all of the information about where your accounts are, what the account numbers are, what the values are. And so each asset that is on your original funding table ends up in your funding data file. So Alicia then goes into each client's data file and updates each asset that's listed there. So if you think about it, on average, people have 10 assets. If you think about the number of people that we have in the program, multiply by 10, you'll end up with 400 or 500 different assets. And as the program grows, you'll end up with a whole lot of other assets. So that is a very detailed and concentrated effort that Alicia has to go through. And that's why we have the deadline, because we want to give you those updated asset review reports back at the annual client meeting. And so she does a lot of work updating your data file. But that's not the end of the work that she does. The next thing that she does is she generates and reprints each updated asset review report, so that when you come to your annual client meeting, she can take the document and put it into your Blue Book in the Keeping Current tab, so you'll have it for next year. So she takes it, she puts it in the Keeping Current tab, and there it is. Now, When you get your asset review report, you'll note that on the left-hand side, next to each line, there is either a check mark or an X or a star or no mark at all. Now, the check mark means that we have fully verified that the asset is funded the way you've instructed us to do. The star means that we're still waiting for some stuff, or that it may be an asset that is a special type of asset that can't be funded. Then an X indicates that it's an asset that we have decided together not to fund for various different reasons, like an automobile. And then if there's no check mark next to it, no mark at all next to it, that means that we have no verification that the asset is actually funded the way it is. Now, fully funded living trust is what we're aiming for. And you know, it's very good to have fully funded living trusts, but it's also very important that you're a fully funded living trust, that the funding actually be completely verified. And I want to put the emphasis on the word verified, because what happens then is, let's think about this. When you know, if something happens to you and your family calls us up and they say, you know, something happened to my loved one, I want to know, is everything all set? And you know, what you want us to be able to tell them is that everything is fully prepared to proceed as designed. You don't want us saying, well, things are almost fully prepared, or things are partially prepared. And what that means then is that every one of those items that you've got that doesn't have a check mark next to it means that we're not able to say everything's all set. We're all ready to proceed with the estate settlement. So if your primary goal, and most of our clients' primary goal, is to make sure that things go smoothly for the people that they leave behind, if that's your primary goal, you want to have check marks next to every item on your asset review report, except for those items that we've determined not to fund. So please note that. Now, for folks attending this webinar, I want to make a couple of notes. We will be sending your updated asset review reports to you with instructions about where to put them in your Blue Book, because obviously we can't update your Blue Book online. And we will also be sending you a registration for your CUP. If this is your client update program year, and you know, we have half our clients 1 year, half of our clients the other year, and we're updating everybody every other year. So if this is your update year, you need to register for the various different meetings that we've scheduled for the updates. And that's going to be a blue sheet. So Alicia will be sending you the blue sheet as well as the asset review report. We need to get the blue sheet back, and the deadline is July 15th. So we need to get all that back by then. So those are the administrative notes. So the Step 2 program, again, I want to repeat, is a group program. It's designed for things to go smoothly and inexpensively. Please note the emphasis on the word inexpensively. There is an alternative to a group program, and that's what I would refer to as a concierge program. So what does concierge mean? Well, I looked it up on the internet, and this is the best definition that I could find. A personal concierge service runs on the most basic of premises. People want things done, but they don't have the time to do it themselves. But they're happy to pay someone to take care of their business. That's from entrepreneur.com. And remember, the Step 2 program is not a concierge program. So what we're trying to point out is if you look back at the things that I described about what Alicia does, that's what is included in the program. A lot of other things that sometimes people send back their updates saying nothing's changed, as I mentioned, and well, of course, they make no notes about what the value of their assets are. So we need to know the values to have them updated every year, and that's very important. So it causes Alicia to have to go back and start over again for those people, and then she's running up against a deadline to get things done by the annual client meeting. You know, so it's really important that we have the clients, it's their responsibility to fill out the asset review report and to make sure that it is filled out. One of the things that we run into as a problem is that sometimes people ask us to send the asset review report to their financial advisors so the financial advisor can fill it out. That makes it difficult because most of the broker-dealers have security protocols that mean that they're not able to download documents securely. So, you know, we have a secure download system. We have a system where things are stored and you can download them by going in online. But many of the broker-dealers aren't completely unable to do that because of the security protocols in their computers at the office. So what does that mean? Well, that means then that it has to be mailed to them, which again adds additional time and effort for Alicia to go through to get everything done by the annual client meeting. So we really do ask people for their cooperation to take responsibility to send copies of their asset review report to their financial advisors, collect the information from their financial advisors, and then send the information directly into us after it's all complete. So, you know, we could actually do a concierge program, and I brought this up actually at we have telephone conferences with the National Network. I brought this up at one of the telephone conferences that we have to talk about our maintenance programs. And I said, you know, if I were going to do a concierge program, I want to make it clear to my clients that the Step 2 program is not a concierge program. And so I'm thinking about what I would charge. And they said, well, what would you charge, Frank? And I said, well, maybe $1,500. And they said, oh, no, not enough, Frank. It has to be at least $2,500. So, you know, this is not what we want to do. We do not want to have a concierge program. If people want a concierge program, we're very happy to provide it. We have to figure out what the fee would be. But the Step 2 program, again, is not a concierge program. So we do rely on our clients to help us by filling out the forms the way they're supposed to be filled out, sending them back to us the way we have presented them, because the forms themselves, the asset review report, is configured so that Alicia can go through each set of assets, and those are all lined up with the computer program that we use to open your data file. So she can very deliberately and orderly go through all of the assets to you know, get the assets put in correctly. If they come in a different configuration, or all we get is statements and we don't get the actual review report that's been updated, then Alicia has to do a lot of detective work, and that just adds a lot more, and extra time puts a lot more pressure on her. So the program isn't really designed for us to have to do that, and so we do ask for our clients to help us by cooperating in that way. So again, the point of the Step 2 program is designed to minimize the overall cost of your estate plan. And you know, this is the slide that comes from the 2000 estate planning program, and you can see that in the upper half of this slide, It's designed to be a teeter-totter, and so the idea is that people pay a slightly bigger fixed fee up front to get a personalized plan. And I would point out that because we spend so much time with our clients, although the fees may be a little bit higher, we don't actually bring in a lot more. We don't bring in more revenue than other attorneys do estate planning. It's just we have fewer clients and we have better relationships with them. Then the maintenance program is the first year is $995 and $595 a year is currently charged, and then we get to the end at the lower end, and that's 1.25% of the value of the assets at the time of death is the cap. That's a guideline, and the cap is we're planning not to go over that cap. And if the client's helpers have participated in the program, there is a program discount so that the cap is reduced to 0.75%. And we do that because the helpers, your helpers, have educated themselves and they know what to do and how to do it. And they also know how our program works in terms of paying for it. And so the estate settlement and administration fees are reduced. The bottom half of this shows a variable system which is available to clients when they come into the program. And I will tell you that it's a smaller price up front, but a much bigger price at the cost at the time of the settlement administration. And you might expect that because people who pay less up front typically less committed to the program. And so it does actually cost us more to actually settle their estates. But I will tell you also that no one has ever adopted the variable system for pricing, so that's kind of irrelevant at this point. So just to review, a fully funded plan is one that gets the 1.25% cap. And by fully funded, we mean that all of the assets on the asset review report are checked or not funded per client, and that's that X mark. So the fully funded means that, and it also means that everything is verified, meaning we have paperwork, documents that verify that the title is as we have agreed that it should be based on your instructions. It's when the helper participation then reduces the cap to 0.75. But if there are assets with no check mark, what that means is that you are not fully funded, and that we have not, you may actually be fully funded, but we haven't verified it. And so we're potentially not able to do the settlement at the cap. It's going to be more expensive for us to find out what's actually going on, whether it's fully funded. And so that's why we need to have verification, because potentially we could end up with a probate. And if we have both probate and trust settlement, then that significantly magnifies the settlement costs of settling an estate. So it means then if you have assets with no check mark, that it's likely that the 1.25 cap we will not be able to offer the 1.25 cap because we do not know that everything is fully funded and verified. So I wanted to make that clear so that everybody understands it's really important to make sure that everything is checked and that we have the paperwork that verifies these things. So I'm going to open up the program for discussion. Feel free to unmute yourself if you want to ask any questions. Well, okay. Looks like we don't have any questions, so I'm going to continue along. So this section is about business continuation planning, or what happens if something happens to you, Frank? And this is the question that we began to really address last year after Christine left. And so I wanted to give you an update of where we are on that. Now, you may remember, I believe that we presented this to you last year. The National Network of Estate Planning Attorneys has a business model that is represented by this so-called practice evolver. And this also is one of the slides that's shown in the Truth About Estate Planning. So up front, the counseling and design process, typically we have a larger cash flow or larger fees, but we provide more preparation and counseling and more detailed work, so we end up with fewer clients but better relationships and not necessarily more dollars. In the middle there we have the maintenance and education program. It's priced to cover the overhead for the program, and it's also priced to encourage participation. As you might imagine, because we know that our clients' plans are being updated on a regular basis, so that we can, if there are changes in the law that really affect them, we can make sure that the changes in the law are accounted for. That reduces our stress. Because also of the annual fees, it also assures that the team understands that they will have a position through client service and performance going forward, even if the attorney isn't there, provided that there's someone to supervise them as an attorney. So it does provide the extra cash flow. Also, the maintenance program does provide us with additional client referrals, which is always very appreciated. And it also is significant for us to say that it increases the number of clients who actually hire us to do estate settlement. So if you wanted to think about it, you might wonder over the last 20 years, what is the percentage of clients who have been in this maintenance program whose families actually hire us to settle their estate if they die or if they become disabled? And the answer to that is, in our practice, 100%. In the national network, the answer to that is about 99.5%, or 98 or 99%. So it's a very, very high percentage. And when you think about it, if the family is able to take advantage of that reduced fee cap, even if they shop around, they're going to find that, well, they know these people, we know these people, they're providing us a service on a systematic basis. It's less expensive than if somebody is starting all over again. So, you know, people do hire us to do the estate settlement. And then on the right-hand side, what that means then is that we know that we're going to be profitable going over time, even though the fees are less, because we know that everybody's prepared. We can offer the services on a reduced basis. But you know, the thing about estate settlement is that the demand for estate settlement is invariable. Let's put it that way. So you'll always know that depending on how many clients you have in the program, there's going to be a certain statistical number of people who die every year. And if you add up all of the assets that all of our clients have and divide by the number of clients, you can kind of get an idea of what the actual estate settlement fees will be by multiplying it by 1.25 or 0.75 on an annualized basis. And what that does is it gives someone looking at the practice the idea of a predictability of profit. And it allows for succession planning, because it allows a new attorney to realize that, okay, if I can actually calculate what the value of this practice might be going forward for, you know, retirement, disability, and death, and all of that works pretty well in this business model. So in our business continuation plan, of course, you all know Bill Coyne. Our short-term business continuation plan is and Bill and I have an understanding that if something happens to us, either for disability or death, we're going to step in and continue to serve each other's clients. But remember, Bill and I are roughly the same age, so that is really not a long-term solution. So it's one option for us is to offer you the maintenance program of another existing firm that is not in the national network. Now, over the last year, let me just sort of tell you that I've gone through a number of different, last year I was having discussions with a couple of attorneys. They decided to opt out because they were happy doing what they were doing. Then I had some discussions with a former National Network member, and she seems to be very happy with her practice. She described her maintenance program to me. It is an individualized optional maintenance program, so that it is not a regular systematic program, and our discussions really didn't get very far. And then this year, towards the beginning of the year, I remembered that there was an attorney that I'd met in one of my networking groups, and so I approached her because she has a successful practice and I respect her. And she and her partner and I had a number of different discussions about how this might work. But in the process of that discussion, what I found was, although they say they have a maintenance program, what that really is a voluntary program. They notify people every 3 years that it's time to come in. Every year they have one voluntary education program, and they do not keep track of the client's assets. And so, although I looked at that, they thought that they could meet the commitment for the caps of 1.25% and 0.75%, but although they may say that, if in fact they're not able to meet the cap, I would worry that my clients aren't actually getting served over time the way they should. And attorneys are kind of odd this way. The attorneys tend to prioritize the cases where they have a larger fee. And so, that's something that tends to have that prioritization issue tends to make me be a little bit pessimistic that someone who doesn't understand how the system works and doesn't have a maintenance program the way we do it would be able to fulfill our promises to you. So that is an ongoing option, but I suspect that most of our clients would not consider that a viable option, and we did actually at our prior meetings ask for people to raise their hands, and everybody raised their hands and say no, they didn't think that was a viable option. So moving our maintenance program to another existing firm so far doesn't seem like a viable option. Another option is to hire an associate. Now, that was what we did with Christine, and Christine was a very different kind of hiring because she was very familiar with the practice. But the network members have had a lot of experience with hiring associates and not good experience. In a lot of cases, what's happened is that the associate ends up working for a couple of years, and then could I ask that everybody mute their phones because we're getting some feedback. So what happens is that the network has been kind of working out what is the system for having the training and hiring of an associate so that we don't hire our competitors, so to speak, or hire people who are going to leave and go on their own, that their incentive is to stay in the firm. And so the difficulty then is how do you do that? Well, last spring at the Collegium that I went to in Indianapolis, you all probably, if you're a Florida client, you know Jeff Kramer. He's the attorney in Florida that we're working with to update the documents of the Florida clients. He and I were at the Collegium together, and we were chatting, and he was telling me how he was happy with his associate, although he had some concerns because she didn't seem to be working as hard as she had been, and she wasn't fulfilling her various different quotas of time. And then on Thursday of the collegium, she called him up and said, "I'm leaving," which was a big blow to him, somewhat of the same kind of blow that I'd had when Christine decided that she was going to leave. And so Jeff and the chairperson of the network, who's actually gone through the hiring process several times with the same results, decided that they would get together and formulate a method for hiring an associate that would actually incentivize people to actually stay. And they did a great job over the last year. And so we now have a proposed contract and a proposed arrangement where we can hire an associate on a basis that they learn how the program works, they get paid over a period of time, but they gradually buy into the practice and end up being partners so that they aren't incentivized to leave and start their own practice. So I'm looking at that as a potential option. The third option is to recruit new network members. So how does that work? What that means is if we had a bunch of network members in Eastern Massachusetts of various different ages, I could kind of pick and choose who I wanted to talk to about taking over my practice. So for a long time, the network has not been recruiting new network members for a bunch of reasons. The result has been that there haven't been a whole lot of new network members. But also over the last year, because of the way things have been done, the recruiting system has really begun to go. And I now have two Massachusetts attorneys in the pipeline in the recruiting system who are going through the training. So that's important. So, you know, things are developing along the way they should be. So, you know, long-term solutions are new attorneys recruited in the network. There is a 2 to 3 year learning period to learn about how the system works and to be trained about how to do it. During that time, the network attorney, or after that time, no, I'm sorry, during that time, the network attorney, they join the network, they become a network attorney. They become of counsel to me, and then gradually there's a transition of management to the new attorney, and then continuation of my services as of counsel. So that would be the long-term approach. Now, the of counsel arrangement is a very useful one, where you don't have to hire somebody to be an employee and they're basically developing their practice. But it's also very difficult to do with anybody who's not a network member because of the intellectual property. I can't share a lot of the intellectual property that we have in the network with non-network attorneys because my job is to protect it. So, and we've had a number of discussions about how that might be done, and it really is impossible to be of counsel and train another firm to do the process if they haven't actually joined the firm. I could join the firm and be a member of that firm and do it and train them how to do it because they would be sharing liability with me. But as not a member of the firm and outside counsel, being of counsel doesn't work. So that's an impediment. So there's two main solutions. One is to hire an associate, and another is to recruit new attorneys to the network. And we're working hard looking at all of those. So I just want to open it up and see if there are any questions so far. If you'd like to unmute yourself, feel free to let me know. Just I'll just wait a couple of minutes. All right, well, we don't seem to have any questions, so I'm going to proceed to the next section. So this is the technical presentation. There's a couple of things that I want to go over. The first thing is, one of the key aspects of estate planning is creditor protection. That's all about the school bus story. And there have been some recent developments where we're really concerned that the creditors can get into our trusts, and so we're watching out various different things. The first case is one that happened in 2014. It's called Clark versus Ramaker. This is a case, it's a bankruptcy case that ended up getting appealed to the U.S. Supreme Court. And in the bankruptcy context, IRAs, retirement accounts, can be exempted from the bankruptcy if the bankrupt person elects to do so. So retirement funds are exempt from claims by creditors. There's a particular provision that allows that. Mrs. Clark had inherited an IRA from her mother, and she and her husband ended up having difficulties, financial difficulties, so they filed for Chapter 7 bankruptcy. The bankruptcy trustee said, well, wait a minute, that inherited IRA isn't what we mean by retirement funds within the definition of the bankruptcy code. So the trustee sought to get access to the retirement account. It was $200,000 or $300,000, which would have been a substantial difference in what the creditors got. The bankruptcy court, the local bankruptcy court, agreed with the trustee, and then Mrs. Clark and her husband appealed to the appeals court, Circuit Court of Appeals in the federal system. The Circuit Court of Appeals agreed with Mr. and Mrs. Clark, holding that it was retirement funds, and so the trustee appealed to the Supreme Court. And the Supreme Court held in favor of the trustee. They said that if you think about it, a retirement account that you have, that you've established, you've got restrictions on when you can take out distributions. You can't take them out before you're 59 and a half. And if you do, you get a 10% penalty with some minor exceptions. And you have to take distributions at being at age 70 and a half. And so, the whole system is designed to make sure that you save for retirement. An inherited IRA, on the other hand, doesn't work that way. In an inherited IRA, the IRA owner has to take out minimum distributions beginning when they receive the account based on their life expectancy. And minimum distributions don't start at age 70 and a half. They have to start taking it out now. And there's no age 59 and a half either. They can take out as much as they want. They don't have to take out only the minimum. So the bankruptcy trustee's point was, well, that's not really a retirement fund. That's really just a fund that allows them to have tax-free increase in the value until they take it out. But it's not really a retirement fund. They're not retired. And they can have access to the account. And the Supreme Court agreed with them. So the result of that was that we found that the Supreme Court held that inherited IRAs are not exempt under the bankruptcy code from claims of creditors. Now, there are state exemptions. If you're not in bankruptcy, there are all of the 50 states have various different approaches to exemption of retirement accounts. We're not sure if those different approaches would apply to inherited IRAs. But you can see why we have been urging that clients designate trusts as the beneficiary of their IRAs so that they could take advantage of the school bus protections after the IRA owner dies. If the trust is the beneficiary of the IRA and it isn't in the hands of the beneficiary, then it's not subject to the beneficiary's creditors. So then we have what's called the Pfannenstiel case, and this was decided last year. And this is a case where, and we have an old expression in the law that we learned in law school called bad facts make bad law. Mr. and Mrs., this is a divorce case. Mr. and Mrs. Pfannenstiel were married in the early 2000s. Mrs. Pfannenstiel had been in the Army. She decided to leave the Army to marry Mr. Pfannenstiel. And she'd been a master sergeant or something like that. So she gave up her career to marry Mr. Pfannenstiel. Mr. Pfannenstiel, on the other hand, was not a very successful person. He had ADD, apparently a bad case of it. He was only able to finish like 1.5 to 2 years of college, and he was working in a bookstore. Well, as it happened, the bookstore was part of a for-profit college, and the for-profit college was actually owned by Mr. Pfannenstiel's family. His parents, as a matter of fact, had owned an entire system of for-profit colleges. A very, very profitable business. And they had contributed stock in this business to a trust for the benefit of their, I believe it's 3 children and grandchildren. Mr. Pfannenstiel, of course, was one of the 3 beneficiaries. And his brother was the trustee, along with an attorney who was the family attorney who represented the parents of Mr. Pfannenstiel and who had established the trust. The attorney didn't pay much attention to distributions. All the distributions were decided by Mr. Pfannenstiel's brother. Well, the trust was established in 2004, and 2005 and 2006 the trust started making very large distributions to Mr. Pfannenstiel, enabling him and his wife to buy a very expensive home, and the distributions were $100,000 to $200,000 a year, a fairly substantial contribution to their household. But unfortunately, a couple of years later, Mr. and Mrs. Pfannenstiel decided that they were going to have to get divorced. Mr. Pfannenstiel was going to file in September, and in August of that year, guess what? The distributions from the trust stopped. Now, the distribution provision in the trust said the distributions could be made for health, education, maintenance, and general welfare of the beneficiaries. Didn't mention their dependent children or spouses. And so in the divorce, the issue was, and you know, that does, if you think about it, all of a sudden they're not making any distributions to Mr. Pfannenstiel anymore. He's still earning his income at the bookstore, but the money is no longer available for support of his wife and children. And so Mrs. Pfannenstiel asserted that the trust, or his interest in the trust, should be considered as part of the marital assets and valued as such, so that he had his obligation to support her and her children should be based on including that trust in the value of their marital estate. And the divorce court agreed. And the divorce judge, the probate judge and the divorce valued Mr. Pfannenstiel's interest in the account and made an order based on that. Mr. Pfannenstiel then appealed to the Massachusetts Appeals Court. Now, if you think about it, this is a trust that is a common trust. They didn't have separate shares. It was a common trust for the 3 children and the grandchildren of his parents. And distributions could be made to all of them, and the distributions were discretionary. If that sounds familiar to you, then that is very much similar to the way most of our trusts have been designed. I would also say that a few years ago, Massachusetts passed the Uniform Trust Code, and you may remember that we were watching the Uniform Trust Code adoption because the Uniform Trust Code in its original form allows certain types of superior creditors, like children entitled to support, to stand in the shoes of the beneficiary of a trust that they have not created and it takes the position that the beneficiary has a right to distributions if there is a standard of distribution, like health, education, maintenance. And so we were watching that very carefully. When Massachusetts adopted the Uniform Trust Code, they specifically excluded those provisions. Those provisions are blank. They just said reserved. They did not adopt those provisions. So the Pfannenstiel court's decision in the appeals court goes very much along the lines of what the Uniform Trust Code, as not adopted by the Massachusetts legislature, is written. They actually said things like, Mr. Pfannenstiel has an enforceable right to his distribution, so his wife and children should be able to take advantage of that. They also said words like, the trust had been woven into the fabric of the marriage. And so the appeals court held in favor of Mrs. Pfannenstiel, and when that decision was done, all the trust lawyers in Massachusetts started looking and biting their nails and saying, well, this is awful. This is not Massachusetts law as we know it in terms of trust law. It's not consistent with long history. Now, the divorce courts have been taking a kind of a different path, and they've been gradually chipping away in the divorce context at some of the protections that trusts have. So this is kind of consistent with that gradual chipping away. Well, Mr. Pfannenstiel appealed to the Supreme Court of Massachusetts. It has not made its decision yet, but it held its hearings on it in May. And though the judges in the hearings were apparently very antagonistic to Mrs. Pfannenstiel's attorney and had very few questions to ask Mr. Pfannenstiel's attorney. So, one judge said, how was this trust woven into the fabric of their marriage? They'd only been receiving distributions for 2 years. So that, there were a lot of different questions that suggest that the Supreme Court disagreed with the appeals court, and so we're waiting to see what the Supreme Court, the Massachusetts Supreme Court, decides to do on that. And we're looking at that very carefully. If they hold, as did the appeals court, then we're going to have to make some substantial changes in how we deal with our distributions and our trusts, and it's going to be a very interesting time for us. So those are the two issues that we are watching in the creditor protection area. From our point of view, I don't really know any clients who would want divorcing spouses to be able to get into the trust. They don't want the outlaws to get into the trust for their beneficiaries. So let's move on to portability and the bounty clause. You may remember that in 2012, Congress changed the estate tax law, changed it so that there was a so-called permanent $5 million exemption. So everybody has a $5 million exemption. And that exemption increases annually by, there's a cost of living increase. And so the exemption is now $5,430,000. And on top of that, if the first spouse who dies doesn't use their entire credit, then their surviving spouse can use it themselves. So if you think about it, if I died and I had only used $1 million of my credit, that leaves another $4,430,000 of credit. If my wife dies and she has a $7 million estate, she can protect her entire estate, even though she only personally has a $5 million exemption, by using my exemption. That's called portability. We can port my exemption over to her estate. Now, when portability came into existence, a lot of attorneys said, well, why don't we just have all of our trusts say that the marital trust gets funded first instead of the family trust, so that we use the marital deduction entirely, and so at the death of the second spouse can use the entire $10 million plus exemption. Well, why would we do that? Well, if we use the family trust and we use the exemption on the first spouse to die, and then the second spouse lives for another, let's say, 20 years, there may be assets in the family trust that have rather low basis. And so when the second spouse dies and those assets pass to the beneficiaries, the successive beneficiaries of the family trust, they inherit very low basis assets. And that means they have a very high capital gains tax if they want to sell them. And so that was the reason why using the exemption and the marital deduction on the first spouse's death, and then using the exemption, the full exemption on the second spouse's death, seemed like a good strategy, because that means that there is a step up in basis on the death of the second spouse for all of the assets. We don't have to worry about those low basis assets. Well, of course, that means that none of the beneficiaries who would be beneficiaries of the family trust get to participate in the plan until the second spouse's death, which may or may not be consistent with people's objectives. And it also means that, you know, if you remember the 1, 2, 3 of estate planning, the family trust is probably the last one that we want to use, because that's the one that's not subject to estate taxes ever again, never has to be. So the National Network members got together and started thinking about ways that we could actually upgrade or step up the basis of the assets in the family trust on the death of the second spouse, and we came to the solution being something called a bounty clause. Now, bounty refers to the quicker picker-upper. So what it means is that it uses up the exemption of the unused exemption of the spouse of the first spouse to die, to increase the assets basis in the family trust. And how do we do that? Well, what we do is we give the surviving spouse a general power of appointment over the selected assets that we want to increase in basis. So, and as you know, a general power of appointment means those assets get included in the estate of the person who holds the power. So that means that the assets in the family trust that are selected for that power, and it's a very complicated provision, but the assets that are selected for that power end up getting a step up in basis, and we end up with no additional tax. And there are some provisions about what happens for estate tax, etc. So the bounty clause is very useful from that point of view. And the power of appointment that's given is it gives the surviving spouse the ability to appoint the property to his or her creditors. And it doesn't say estate, doesn't say creditors of estate, it's just their creditors, which makes it a general power of appointment. But how many spouses are going to exercise their power of appointment to their creditors? I don't know too many, but the mere existence of that power is what makes it part of their taxable estate. And if we have plenty of exemption that we can use, there's no need not to upgrade to step up the basis of the assets. So that's the purpose of the bounty clause. And it's useful for certain types of estates based on the size of the estate. When we do our updates, if it's important for you not to have the bounty clause, you'll be hearing from me to talk about what your options might be. But typically the bounty clause is now included and will be included as a kind of a default clause, unless, and there are certain circumstances where it doesn't make sense. But if there are situations where it doesn't make sense for our clients, and then when we do the updates, then you'll be hearing from me. And the way that we make that determination is by looking at your updated annual asset review report. So please make sure that we have that, because when we're doing our drafting for the update program, we are looking at those to make sure that the income tax aspects of the trusts match what your estate might look like. And because of the very large exemption, federal exemption, a very, very small bunch of estates are actually going to be subject to federal estate tax. So what many estate planners are looking at now is the income tax aspects of planning, and the bounding clause is one of them. And then finally, the net investment income tax and the cookie jar power. The new, what's usually referred to as Obamacare, the Affordable Care Act added a net investment income tax of 3.8% that gets added. It's a percentage that if you are, if you reach the a certain level of income, and for married couples that's $250,000, then you have net investment income, you pay an additional tax of 3.8% of the net investment income. And that's for people who are at the highest income tax brackets. However, trusts, and think about your long-term trusts, are now irrevocable. They have income. Trusts end up at the highest income tax bracket when they have income, and most of it is net investment income, of $12,300 this year. And for most long-term trusts, they're going to have more net investment income than $12,300. So what we wanted to do is to make sure that the trust doesn't pay additional income tax. And there's another aspect to this, and that is that capital gains tax is also included in net investment income. They can also be included in net investment income. They are not subject to the distribution deduction. You may remember that when a trust distributes income out to its beneficiary, ordinary income out to its beneficiary, the trust gets a deduction for the distribution, so it doesn't pay tax on the income. The beneficiary pays tax at their bracket. And in most cases, the beneficiary of a trust has a lower bracket than the trust itself because of that very low point at which you get to the highest bracket in the trust context. So what we wanted to do was to have a way to allow the net investment income to be considered income of the beneficiary. And so what's been another very complicated tax clause has been added and can be added to everybody's trust, and it will be added as a default unless based on your asset review report does make sense. We call this the cookie jar power. So what it means is that the beneficiary has an ability to withdraw the assets from the trust to the extent that they would be subject to the net investment income tax. So what that means is, and that makes it subject to that makes it taxable, income taxable to them, under the income tax law. So we call this the cookie jar power because we use the following story. When I was a kid, I used to come home. Sometimes my mother wasn't home, and I would say, "Oh boy, I'm going to go to the cookie jar and I'm going to take a cookie out because I really am hungry." So I would go to the cookie jar, open the cookie jar, reach in and take a cookie out or two, and then I'd go on up to my room. And then my mother would come home later and she would call up the stairs, "Hey, you've been in the cookie jar." And I always wondered how she knew that. But looking into the cookie jar and putting your hand in the cookie jar, that's why we call it the cookie jar power. It gives the beneficiary the ability to reach in and withdraw this net investment taxable income. So that's the cookie jar power, and that's another technical development that we are adding to our trusts this year. So that's our technical presentation. I want to just take another pause and ask for questions. If you're attending, please feel free to mute yourself and come on in and ask some questions. Well, okay, the presentation is going to be has been recorded. It will be made available through the Step 2 website, and you will all get an email notifying you that it's available so that you can download it. Actually, I'm not sure it will be made available through the Step 2 website because we're only making this available to the people who were unable to make the June 17th annual client meeting. So we will send you a link with the YouTube for it after it's been uploaded. That will probably sometime next week. So again, I want to thank you all very much for attending. And if you have any questions that come up in your head, please feel free to call us. I'm not actually in the office today, but you can certainly call me next week. And I look forward to hearing from you.